Yeah.
Very good morning to one and all present here. On behalf of GIT, I, Professor Shreya Patel, Assistant Professor from Computer Engineering Department, welcome you all to the webinar on Intellectual Property Awareness, organized by GIT IPR, GIT SSIP, and GIT IQAC, along with National IP Awareness Mission and Intellectual Property India Geographical Indication. I warmly welcome our guest, Mr. Arpit Jain, sir. He is an examiner of Patent and Design Patent Office at Mumbai, DPIIT, Ministry of Commerce and Industry at Government of India. Before proceeding further, I would just give a thankful note that any initiative step towards connecting people and coming together for auspicious events such as in webinar. This webinar is also one such opportunity given by our trustees, director, Sir Dr. H.N. Shah, towards which we extend our heartfelt gratitude. On this beautiful on this beautiful morning, I would like to take the privilege to introduce our guest of honor today, which is Mr. Arpit Jain. Sir is working as examiner of patent and design at the Patent Office, Mumbai, Government of India. So primarily deals with examinations of application filled for patents in the field of electronics and telecommunication engineering. So is also an editor of IPR newsletter for the office of CGPDTM. So is also working as an informant expert of IPR and patent agent examination, which is to be held in May 2022. So has completed his Bachelor's of Engineering in the field of Electronics and Telecommunication back in 2015 from IET DAVV, Delhi, Ahilya Vishwavidyalaya, Indore, MP. And sir is a higher secondary education passed out back in 2011 from Sri Krishna Memorial School, Guna. Without wasting much of your time, I would like to hand over the command over to Mr. Arpit Jain, sir. Over to you, sir.
Ma'am, my voice is clear, fine?
Yes, sir, you're totally audible.
Fine, and my screen is visible?
Not yet, sir.
Okay, just a minute.
Sure, sir.
Now it is visible?
Yes, sir, it is totally visible.
Fine. So, hello everyone. Thank you, the Institute, for providing the opportunity to the students of this college awareness session on intellectual property. Now, coming up to the intellectual property is what? Intellectual property is something that is, you can say, intangible. You cannot touch it. Please, you can mute yourself. All the people, they can mute yourself. Hello, because there is a echo. Yes, fine. So IPR is what? When I talk about intellectual property means something that is intangible. Means you cannot touch it. But your physical property like gold or home or your house, they are what? They are, you can say, they are your they are the physical property. When we talk about intellectual property rights, these are the rights that are associated with your intellectual property, say patent, trademark, copyright, geographical indication, or designs. IPR is a collective term for intellectual property. It is the legal rights which result from intellectual activity in the field of industrial, you can say, innovation, scientific research, literary work, or artistic fields. Coming over to IP, again, we are defining intellectual property in a sense, you can say, like creation of human mind. You have some idea in your mind and you want to express it. When you express it, you convert that intellectual property, that idea, into a physical property. And that's why it is said intellectual property is what? Creative idea and expression of the human mind. And when human express this idea or expression in the form of physical device or say model or anything, that becomes a physical property and that have a commercial value. So intellectual property in brief, you can say it is the creation of mind. It can be bought, sold, exchanged like any other form of property. Imagination is more important than knowledge. Why it is said? Because say you have a problem, okay? You have a problem, and whatever you have, okay, whatever you have in your literature, okay, your research papers, available knowledge, the common general knowledge available, you should imagine beyond this knowledge to solve your problem. Say you were just think of that Nokia 1100 phone. The phone was not having any, you can say, video calling feature type of thing. Then the researchers might be thinking about how to add more features in this phone, okay, or make a new phone. So that is what the Nokia 1100 was, the existing knowledge, and you have to think beyond this knowledge. You have to imagine beyond this knowledge, and that's how you innovate and you create new things, and that gives rise to intellectual property. Intellectual property is the solution to your problem. Taking the example of the bulb or the computer, all these things were invented because man was having some problem. We were having some problem. We cannot do so much computation and calculation with our conventional system. That's why the scientists or researchers worked on and developed a computer or a bulb. So there was a problem, there was some knowledge, you think beyond this knowledge, you imagine, okay, you innovate new things, and that is called as intellectual property. And when you realize it in the form of a physical property, it is a solution to your problem. Coming over to how we create intellectual property, you have some resources, say resources in the form of, they might be your mentors, faculty guides, okay, your books, your literature, research papers already published. These are resources. You apply your brain, you take the you can say you take the advice of your faculty. That is what? That is the brain part. Third part is the labor part. You put a lot of hard work in terms of, you can say, years or months to develop something, and that is called an intellectual property. Just like similar to your university exam or your engineering exam, what do? You have some resources, you read some content, you apply your brain, and you put some hard work, and that's how you clear an exam. In the same way, you create intellectual property. Why we need intellectual property protection? Why there is a need for intellectual property protection? So because technologies are changing rapidly. Why it is said technologies are changing rapidly? Just take an example of WhatsApp phone, okay, WhatsApp app, okay. So it was having a, you can say, 4 people video conferencing feature, but now we thought that we need some advancement, we need more people, so they increased the features to 8 people can join a conference call. That is how technology is changing rapidly. Even in some fields, technology is changing in minutes, or you can say in hours. So these technologies are changing rapidly, and it may happen that your idea may be stolen by any third party. It may happen that your idea may be stolen by a third party, and if somebody stole your idea, your all work will be in vain. They can do what? They steal your idea, fine. what they will do, they either register it or they will start selling your product. So that's why it is said in this you can say in this dynamic world we need to protect our intellectual property rights. What is the advantage of protection? See, you protect, you register your intellectual property right. Say you invented something, you registered, you filed a patent application in the patent office. Okay, so you protected your invention by filing an application and you are excluding the other world because you are the first person who filed that application. Okay, so now you have excluded the whole world. Nobody else can file that application. If they are filing, then you will have the priority because you are the person who created it and who filed it first. That is the advantage of registering you can say your IPRs. So the day you file an application for intellectual property, you exclude the other world and then now you can utilize, commercialize and you can earn from your intellectual property or your creation. What are the objectives of you can say protecting IPR? There are two types of rights. One is moral right. Since you are the inventor, say one student of GIT Gujarat, they have you can say he invented something, some model. Okay, so since he is the inventor, he is the creator, he should have all the rights associated with it morally. Okay, and second about the commercial rights, all the commercial rights should belong to him or her only. Why? Because he is the sole creator, he was the original person who created it. Okay, so he should have all the rights, and that is the objectives of protecting IPR. Your two type of rights, you can say moral rights and economic rights. Coming over to intellectual property rights, now we have various categories. Patents. What is patent? Always remember, people have a lot of confusion in the market. They don't know. In the colleges, you can say in the schools, they don't know what is patent. Patent is always granted to technical advancement, technology part, or invention. Patent is not given to a book. Fine, a book, you will be having a copyright registration for model, invention, technology, technical advancement, technical effect. Okay, for that patent is given. Okay, patent registration is done for inventions. Design. Take the example of this phone. The technology part inside this phone, you can register it for a patent. Say 5 students of GIT Gujarat, they have invented this mobile. Fine. They made a new mobile phone. Fine. Now, for the technology part, they can file a patent application. Fine. Second is design. For the outer appearance of any object, you can file a design application. For example, say the pattern on the back cover of this phone. Okay, just you are seeing the back cover of this phone, and you can see this is the outer appearance of this object, the texture, the pattern, the color. Okay, the surface. Okay, the surface, the texture of the surface. These all things are outer appearance of that object, and that's why the 5 students of GIT Gujarat will register for a design. Okay, so for the same phone, they can have a technology registration. You can say it will fall under patent category, and for the appearance of this phone, they can file a design registration. Now, these 5 students, they want to open their company. Okay, so they can give it a name ABC Mobiles, and that will become the trademark. Trademark. Why you need trademark? Trademark you need because you want your customers to know your product by some logo, by some name, by some tagline. For example, you have LIC tagline, Jindagi ke saath bhi, Jindagi ke baad bhi. These type of taglines create a sensation in the mind of customers, and that's why it is said that whenever you are having a, you can say, you can say any business, you are opening any business or any organization, you should have a trademark so that the people will recognize your product by that trade name or trademark or tagline. Fine. Coming over to geographical indication. Geographical indication means geographical speciality of a region. Okay, say Agra ka petha or Chanderi sari, or you can say Kashmir saffron. These are what geographical speciality of a region. These are produced or manufactured in that area of India only. Like Agra ka petha, petha is made that variety of petha is made in Agra only and not elsewhere in India. That's why it is called as a geographical indication. Fifth one is copyright. What does you mean by copyright? Copyright is about preventing the protecting the original authorship, protecting the original authorship. Say this paper is written, okay, paper is written by some company, okay, and now who is the original author? That should have all the rights. Okay, that person should have all the rights, and that's why it is said whenever you are publishing any content, making any painting, sketching, drawing, okay, engineering drawings, etc. These things are registered under what? The copyrights. Copyright is about protecting original authorship of any content. SICLD is what? You are working with a lot of electronic devices, and these have what? ICs inside them, intellectual, you can say integrated circuits, and various companies who are making new devices, they make new ICs, and the companies register them because otherwise some other company will copy them. So this is their sixth intellectual property. Now coming over to seventh intellectual property, it is plant varieties. Nowadays you will find a lot of plant varieties also coming in the market, and this also falls under intellectual property protection. Coming over to copyrights, copyright is given to what? Okay, I told you about what? The protection of original authorship of what? Artwork, musical work, your all music, okay, your sound recording, your sound mixing part, these all things of any movie, serial, these all things fall under copyright. Your broadcasting rights, performance rights, all these things, films, sound recording, and you will often find a lot of images or a lot of content you will find see inside a circle, and this is called as what? Copyright protection. Copyright is given in the field of literary work, films, dramatic, musical, artistic works, sound recording works. Literature work, okay, the students might be there from electronics and communication background, or you can say computer background, okay, electronics background, computer background, IT background. They often work on what? Computer softwares and computer programs. Remember, if you are if you want to protect, if you want to register any computer program or software, you should file for what? The copyright registration. Okay, books, newspaper, your question papers, catalogs, dictionaries. If any faculty is there and they have some lecture and they want to protect it, it will fall under copyright. Now artistic works covers what? Painting, drawing, engineering drawings, photographs, diagrams, plans, musical works, choreographic work, okay, term, play, all these things, scripting or cinematographic film, these things fall under musical works. All the movies you are seeing on the internet or whatever in cinema halls, they all have copyrights for their content. Broadcasters right, you are seeing various serials on TV. These all TV serials, okay, they are coming on a particular channel, they are broadcasted on a particular channel, means the channel has the broadcasting rights. Okay, performance rights, you are having a lot of bands, musicians performing in your college events or outside, these people have performance right. What happens, say if singer is there, I am the singer, okay, and somebody has song I am performing, so I should take the permission from the person who has written that song, because I am performing the content of other person, I should take the permission, and these things fall under copyright protection. Who is the original author? Whenever we talk about literature, literature means any paper. Say this paper is written, fine, okay, or this paper is written. Okay, all these papers will, you can say the owner will be who? The author. I talk about musical work. Say the songs inside this phone. These things, the owner will be whom? The author will be whom? The music composer. For any photograph, we will say the photographer is the owner. For any film, we say the producer is the owner. For any computer generated work, nowadays various and various musicians and bands, they generate some computer work. They create new tunes, or you can say new programs on computer. And for all these things, who will be the owner? The owner will be the person who created that thing on the computer. This is about copyrights. The piece structure is given here. You can read it later on. I will share the slides. Coming over the how do we check your copyright application? Whenever you file an application, we do some formality check. What is this formality check? For any intellectual property filed, application filed, say patent, design, trademark, copyright, or geographical indication, we do a formality check. We always check whether the piece is paid or not, whether the timeline is met or not. If yes, the formality is check is done. Now waiting period. You are filing, somebody else is also filing, because a lot of people are filing applications for copyright. So you will be in a queue. That is called as waiting period or buffer period. Now comes scrutiny part. In the scrutiny, we check whether your content is genuine or not. We have a database. We check whether whether in our database similar content exists or not. If there is no similar content existing in our database, you will get your copyright approved. Otherwise, what will happen? We will issue a discrepancy letter. He will say you, this part is already matching with this content published on this site or this newspaper on this date. Okay, that is called as discrepancy letter. Then you will provide a reply. If your reply is found satisfactory, then you will get your copyright registration approved. If your reply is not satisfactory to our requirements, then what will happen? You will be provided a hearing. Hearing may be online or offline mode, and in that your work, you can say, will be decided whether you will get a copyright or not. This is the procedure that how you get a copyright registration for your work. Okay. Coming to design, again we are talking about the outer appearance of object. Whenever we talk about design, we never talk about the process of manufacturing or technology, because technology and manufacturing it falls under the category of patents. Outer appearance, the pattern, the line, okay, or you can say the configuration part, the color, outer appearance, the aesthetic aspect of any article, these things fall under design. You can see a lot of designs are there for the portals, and the companies who have made these designs, who have developed these designs, they will always register them. Otherwise, what will happen if they don't register? Some company will register it first. That's why it is said, whenever you create an intellectual property, file an application for registration. Say it may be patent, it may be design. For this device, you have 3 applications. You can file 3 applications. For technology part, you can file a patent. For the outer appearance part, you can file a design registration. Okay. Third thing is, you want a name for your company, you file what? A trademark application. Now you have a lot of milk bottles here. You can say a set of milk bottles. So design also apply to a set of articles or a set of chairs shown from a well-known movie. All is well. Okay. So these things fall under design. How we process your design application? Our design applications are, you can say, examined at Kolkata office. Okay, and whatever the applications we receive through our 4 branches: IPO Delhi, IPO Mumbai, IPO Chennai, and Kolkata. These things all, these applications all digitized and processed to IPO Kolkata, and there your examination will happen. The same way the examination will happen. Like in copyright, it was, we were scrutinizing your content. In the design also, design application also, we will scrutinize your content. We have a database. We will check whether your design is genuine or not. If your design is matching with some other design, we will issue an objection and you will reply like that. Application fee for design is 1000 rupees, and application form 1. Form 1 is what? Form 1 for any application contains what? The address. Okay, the address for service, the name, okay, and the title of your design. All these things will fall under what? The form 1 part. Now there is something called as power of attorney. If you are filing any intellectual property application on your own, you need not file any power of attorney. But if you are appointing someone else to file any intellectual property application, okay, on your behalf, okay, you are appointing some attorney agent, that is called as power of attorney. You are transferring your power of applying for an application of any intellectual property. You are transferring that power to some person, that is called as power of attorney. Always be clear in this aspect that design, whenever we talk about design, design is only about outer appearance of object. Say the shirt, okay, the shirt is having some checks, and these checks is what? The outer appearance of this object. I am not talking about the manufacturing technology of this shirt. Design is never design registration. We are not concerned about your technology or manufacturing technology, manufacturing process, whatever. We always only see what the outer look, the outer appearance, and should have a visual effect in your eye. Patent office gives you a design registration like this. Okay, you will get a certificate like this for your design registration. Now coming to showing your IP is protected. So whenever you see a lot of intellectual property applications like design, you will find a lot of products having REGD written on them, okay, or RD, or registered is written. What does this mean? These things mean that the design is registered by the applicant. Okay, so if you find any such mark, it means the design is already registered. You always get some 3 months of some 6 months of time. Okay, you file an application, we will check your application, we will give you our objections, you will get a 6 month time to reply, and you can further extend it by 3 months by filing a extension of time limit. Coming over to trademarks. Trademarks means what? Trademark is something, the distinctive symbols that help the customers to distinguish between the competing goods or services. Again, take the example of that 5 students of GIT Gujarat. Okay, and they want what? They want their company, they want their startup to have a name, so that the company products all the company products will be recognized by some name or logo. So that's why you need a trademark, so that the customers will get a feel of your product by seeing your brand name or logo, okay, or tagline. Examples, just like seeing a tick creates a sensation in your mind that it is Nike, or you can say Adidas, or an animal inside a box. What is this? This is saying Puma. M inside a red box. What is this? MACD. Okay, like that. Brand name and tagline. Now talking about brand name and tagline, LG is the brand name. Life is good is the tagline of that company LG. Fine. There is a logo also, G inside L. G inside L, and that is what the logo. Also, often you might be hearing about Airtel tunes. Okay, ding 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 ding, or Britannia, ting ting ting. These things are what? These things are called as sound mark. So you can have a sound mark also for your company. A trademark must not be deceptively similar to the well-known mark. Suppose the 5 students of Gujarat Technology, okay, GIT Gujarat, they want to file an application for the company. They want a trade name ABC Designs. That is okay. But if you are hearing in the market, there are some names called as Abbey Bas or Colgate or Colgate. So these things should not happen. You should not file a name that is similar to already existing brand name. You should always file an application. You should always file an application to the Office of Government of India with a name that is distinct from the already existing brand. Okay, your application for any name should not be deceptively similar to already existing trademarks, and you should avoid geographical indications, deities, national leaders, heroes, symbols, and laudatory words in your trade names. Whenever, say, the 5 students from your college, they want to file an application, the day they file application, they can use this symbol TM, and the day they get the registration, they will get what? R inside a circle, means their trade name is registered. Whenever you get approval from the Office of Government of India, from the Trademark Office of Government of India, you will get R inside a circle, means your trade name is approved by Government of India. Coming over to geographical indication, the geographical speciality of a region, Basmati rice, Darjeeling tea. The name is prefixed here of any location like Nagpur orange, Kolhapuri chappal, or Agra ka petha. All these things are specifying the place name, and that is called as geographical indication. Marvels, Ratlami Seo, Madhya Pradesh. Ratlam is a region, and the Ratlami Seo are famous. Kanchipuram silk, Tamil Nadu. Bark prints of Madhya Pradesh, or you can say barley printings of a tribe in Maharashtra. Warli tribe in Palghar district of Maharashtra, their paintings are quite famous. These all things have been registered by the local artists or local farmers with the government of India that, sir, we only produce this thing, we only manufacture this thing, kindly give us the GI tag. It is called as geographical indication tag. Kashmir saffron, like that. Now coming over to SICLDs, ICs. Now we talk about ICs. So various companies manufacture different devices, and they have what? They have different ICs inside them. And these ICs layouts are, you can say, registered by the companies. You will often hear in the market that two telecom companies are fighting about their IC layouts, or they are fighting about their patent, you can say, patented applications. Okay, so why this is happening? Because it happens sometimes that one company can steal the intellectual property of other. Okay, and they file it before that company. Also, it can happen that two minds may think in the same direction. This is a big world. That's why it is said whenever you are ready with your invention, file your application for patent. Whenever you are ready with your IC layout, file your application for SICLD registration. Because it may happen that somebody is also thinking in the same direction in this big world. Okay, two people can think in same direction. That's why it is said you should protect your intellectual property as soon as possible. Applications, you will find IC applications in your tablets, phones, ECG, or you can say satellite communication. A lot of even we are using these devices, PCs, laptops, okay, cameras. All these things are working on various type of integrated circuits called as ICs. Coming over to the patents, the aim of patent system is what? Patent system, the aim was to encourage, okay, and the aim is to encourage the economic and technological development by rewarding intellectual creativity. What happens? Just think. You invented something and somebody else copied your invention. You made a model, say you invented this phone. 5 students of GIT, they made a phone. Okay. Say some other students of any other institute. Okay. They copied all the features and they filed it first to the Office of Government of India. Who will get the protection? They will get. That's why it is said, if these 5 students, okay, of GIT Gujarat, they file an application for patent, so they will get the protection. And whenever they will see that their device is protected because they filed an application with the government of India, they will feel rewarded because they get the protection, and they will be encouraged to do more innovation. But if they don't get protection, what will happen? They will be discouraged. They will think, yeah, what to do now? Okay, our invention can be copied by anyone else. So why to do more innovation when we cannot benefit academic way, or you can say commercially from any our invention? And why to do more invention? Why we need to do more invention? Do not do any innovative things. Fine, but if you get the protection, you will be encouraged. That's why it is said you get a patent registration. So by that way, Government of India is rewarding your intellectual creativity. Patents, we always check 3 things. Okay, whenever we talk about these three things are novelty. What is novelty? Novelty means novel features. Your invention should have some new features. New features. Say this phone is already existing, so you will be developing a phone that will be having a new feature. That is called as novelty. Second thing is inventive step. The features that are novel in your device, they should not be obvious to any layman. ऐसा ना हो जो आप प्रोडक्ट बना रहे हैं कोई लेमेन भी उसको प्रोड्यूस कर पाए. It should not be obvious to any layman or an ordinary person skilled in the art with very few technical skills. Okay, your invention should have novel feature and they should not be obvious to any person skilled in the art. Third thing is industrial application. Your phone, the phone you made, okay, or any model, any device you made, any small screw, or it may be a rocket, fine. You make anything, it should have industrial application, because if your invention is not industrial applicable, it is not useful for the mankind. That's why it is said your invention should have industrial application. Talking about invention versus discovery. Say something was already there, okay. Say America, it was already there, but Columbus went there and he found out the America. Okay, that is called as discovery. He didn't make, or he didn't invented America. It was not an invention. It was an already existing thing, and he find it out. So if there is already existing thing and you are finding it out, it is called as what? Discovery. But whenever we talk about invention, invention means what? Making a new thing, developing a new thing. Invention means a new product, a novel feature you should have. Involving inventive step means your invention should not be obvious to any person skilled in the art. Your invention should be industrially applicable. Say invention of telephone. Telephone was not existing before the Graham Bell invented it. Okay, so that is what a new thing developed. Light bulb was not there before Edison invented it. So these things fall under innovation. These things were not existing. They were invented by someone. They were developed by someone. Talking about inventive step. What do you mean by inventive step? Inventive step again talks about what? The 3 things. We will talk about novelty, okay, or you can say inventive step and industrial application. So whenever you will find any, you can say patent application, section 21JA will apply, okay, and section 21JA will say what? Technical advancement must be there in your application. Your application, say this is the already existing technology, okay, and your file application, it should have technical advancement over this. You should think beyond this existing technology, and that is called as advancement as compared to existing knowledge. Okay. Then it should have economic significance, industrial application it should have. And the third thing is it should not be obvious to any person skilled in the art. It should have some inventive step. The first Indian patent, you can say, filed by a civil engineer George Alfred Depanning for a efficient pankha pulling machine. Just think about that word, pankha pulling machine. We needed a machine to rotate a fan, and nowadays we have a switch. And now coming to more advanced world, we can operate our phone. We can operate that fan by our phone, and that is what a technology, the smart home technology, the IoT, Internet of Things. So these things we are seeing that the man is developing new things as per their requirement, as per their necessities, as per their problem, and that's how we, our scientists or researchers in this whole world or country, they invented new things because something was missing in the existing technology. Okay, you will find a lot of phones with features. Even you can find inventive step in terms of, you can say, any patent. Okay, in terms of the hangers, small clips. Okay, say the manufacturing technology of this jug. These things will all fall under what? The patent part. So a patent application can be filed for a screw to rocket science. Taking the example of this shoe, Michael Jackson fans might be there. You know, there is a 45-degree tilt in his dance moves. The 45-degree tilt was possible. Why? Because there was a trick in the shoes. The shoes were having some arrangement. That's why he was able to make a 45-degree tilt. And that's how you can say the phenomena of patenting happens. Okay, Michael Jackson, Michael Bush, they got the patent for the shoes. Okay, in United States. And you know what is the advantage of getting a patent? Nobody else can use. Okay, without the permission of Michael Jackson, his shoes. The shoes that are manufactured by these two people, Michael Jackson and Michael Bush, they cannot be used by any other person without their permission. That is the power of intellectual property right registration. Okay, they filed it first. They filed it in US. Okay, so they got the patent registered, also granted. Okay, in United States, and that is the power. You can see invention or an application for a patent can be filed in shoes also. Now, whenever you want to file any patent application, you need 5 forms. Form 1, Form 2, Form 3, Form 5, and Form 18. Form 1 is similar to design applications. Form 1 is about what? Form 1 is about your basic details, your address for service, your title, your name. I will share these slides with you so that you can be more comfortable when you read it. Second thing, Form 2, all your technical part, all your features, your drawings, abstract, summary, existing knowledge and technical advancement part you should mention in Form 2. Form 3. Suppose you are filing a patent application for this mobile. The 5 students of your institute, they are filing an application for patent for this mobile in India. And if they also want to file it in the US, they can file it in US. Fine, but they should inform Government of India that we are filing a patent application for the mobile outside India. Okay, say in US. That is the requirement, and that is the requirement that you have to provide the information in Form 3. You have to provide the information of any foreign filing in Form 3. Form 5 is about what? Declaration of inventorship. Who are all the inventors? Form 18. The day you file this Form 18, okay, your application will be processed for examination. You can file such application. Say today you file your patent application. Today the date is what? 14th of March 2022. Fine. Today if you are filing, then you have 48 months, and within these 48 months from today means 14th of March 2026, you can file your Form 18. And you can file it today also. You have 48 months to file a request for examination. Since your college comes under educational institute category, fine. And who is the natural person? Me and you are natural person. Any person is a natural person. So natural person, a startup or a small entity or educational institute like yours, they can file a patent application at just 5,600 rupees. Okay. And for companies, it is 28,000 rupees, the minimum fee. Online and offline mode, 2 types of application can be done. This is our online portal. Now there is an advantage for some categories. If there is any startup, there is any small entity, or if there is a female applicant, or in a group of applicants there is some female applicant, then in such cases their application can be processed at a faster speed or pace, and that is the facility called as expedite examination, means the fast processing of your application. You will get your first report within 90 days. With this, you can say with this category, expedite examination. Patent application processing. Again, there are three types of ways to file a patent application. I will explain the ordinary part. Say you file an application today, you are 60-70% ready with your invention, you will file a provisional specification. Fine. Now you have 12 months time to update your specification, and that is the 12-month time you can update it any number of times. And the last, you can say, upon the expiry of 12 months, the last application filed by you will be your complete specification, and that will be considered for examination. So you can update, you can file. ऐसा कहा जाता है कि if you are 60-70% ready, अगर आपके दिमाग में एक आइडिया बन चुका है 60-70% your invention is ready, okay, आपका आविष्कार रेडी है, आपका मॉडल रेडी है 60-70%, फाइल इट टुडे. क्योंकि क्या हो सकता है, आप उसको रजिस्ट्रेशन नहीं कराएंगे, हो सकता है कोई नकल करके आपसे पहले रजिस्ट्रेशन करा ले. That's why it is said that you should register it the day you are ready. If you are ready 60-70-80%, whatever you are comfortable, you file it today, update it. 12 महीने के अंदर आप उसको अपडेट करते रहे, and it is called as complete specification after 12 months. Now it will be published by the patent office after the expiry of 18 months. An officer, okay, an officer will examine your application. I am working on the post of examiner of patents and design, so I will examine your application and put up the report to my senior, okay, called as controller of patents and design. They will provide a report to you. You will have 6 months time to reply, or you can further extend it by 3 months. You will get at least you can have a 9 months, and you can further extend it like that. Now, providing a report to you, you will reply to a report. If your reply is found satisfactory, okay. If your reply is not found satisfactory as per our requirements, we will give you a hearing. Hearing may be done video conferencing mode, online mode, or offline mode, physical way. And after hearing, your case will be decided whether it will be granted or rejected. Now, if your application relates to defense of India, okay, or we think that your application may harm defense of India or atomic energy of India, then we will refer it to DRDO or Atomic Energy Department of India for a scrutiny. What we check in your report, what we check in your application. First thing is formal, the fees part, timeline part. Second is technical examination. Technical examination means novelty, inventive step, and industrial application. Providing a report to you called as FER, first examination report. We will get a reply from you. If your reply is satisfactory, you will get a patent granted, or if we found it unsatisfactory, then we will give you a hearing. In the hearing, your case will be decided. After 15 days, your case will be decided whether it will be granted or refused. Now, there is a difference between novelty and inventive step. Novelty means something new, and inventive step means that is something not obvious to any other person skilled in the art. Now, these are the timelines you can go through later on. Patents. Suppose you are filing a patent application today, you will get the protection for 20 years from today. Today is the date 14th March 2022. You will get your application protection till 14th of March 2042. Trademarks, you will get 10 years protection and renewable. Design. Design is what? Design, you will get the registration for 10 years plus 5 years. Now talking about copyrights. Copyright is about you will get a registration for lifetime. Say you are living up to 90 years. Okay, so your work will be protected for 90 plus 60 years, 150 years. Plant protection, if there is any plant variety you invented, you developed, so you will get 15 to 18 years of protection. Talking about ICs, you will get a compulsory 10 years of protection. This is the beauty of intellectual property. See, there's a laptop. For the outer part, the design, length, width, height, and the texture part, you will get a design registration. Fine. For the logo, the apple with a cut, the Apple company might have a trademark. Technology part, they can file a patent. For the ICs, they can file a SICLD design registration. There is a user manual with the devices, okay, and that will fall under copyright. The songs, the music, all these things inside this device, this laptop will fall under copyright. This is the beauty of intellectual property. Okay, you can have all this is the beauty of intellectual property, that a single product you can have 5 number of registrations for a single product: design, patents, trademarks, copyright, and SICLD. Career opportunities are also there in our office. Examiner of patents and design, I am working on this post. Examiner of trademark and GI, for those who are doing LLB or law degree. Okay, for those who are from engineering background or science background, they can apply for examiner of patents and designs. Other jobs are also there, like patent agent, trademark agent. These are the private sector jobs, you can say. Now there is a quiz for you, and you can please unmute yourself and you can answer the questions. Okay, or you can answer in chat box also. Fine. Better if you unmute yourself and answer. Which type of intellectual property protects the painting painted by any artist? कोई आर्टिस्ट है, उसने कुछ पेंटिंग बनाई है, it will fall under which category? Can you please answer yes? If an artist has made some painting, it will fall under which category? You can unmute yourself.
Design registration.
Okay, any other option?
Right. Copyright.
Copyright, correct. So whenever we talk about any, you can say any artist has made some painting, it will fall under copyright registration. Why it is not design? See, whenever we talk about painting, okay, literature work, it will fall under copyright. Design is about outer appearance. This is not a painting, this is the pattern. This is not a painting, fine, this is a pattern. So the pattern will fall under design registration. Second question, what protects intellectual property created by a fashion designer? A fashion designer has created some intellectual property. It will fall under which category? You can have multiple options for this answer. Question. Can you please answer? What can be the options for this question? Fashion designer, just think what they create. It will fall under which category of intellectual property rights? You can please answer. Fashion designer. Can you, is my screen visible?
No, sir.
Okay, I am sharing it again. Fine. Just a minute. Now it is visible, I think. So,
Visible.
yeah. Now please answer. It will fall under which category? Fashion designer created trademark. Good answer. Any other answer?
Registered design.
Okay, good answer. Any other answer? One more option remaining. Two options are correct. I will tell you different situation that how can this be a trademark application. Third thing,
Copyrights.
copyright. Beautiful answer. Now three options are there. Just understand. Say fashion designer ने कुछ property बनाई है, correct. If they are having a painting on it by some artist, it will be under copyright. It will be getting the copyright registration, fine. If they want a logo on their product or their cloth, okay, or on the text fabric, if they have a logo, it will fall under trademark. If they have any pattern like this, any color configuration is there on their cloth, okay, so it will fall under registered design. It was having three options. If you have developed, say, 5 students of your institute, they have developed some advanced disc brake for bike, so they will come to Government of India and they will protect their what? what type of intellectual property they will be protecting? Copyright, GI, patent, design or trademark? You can please answer. किसी ने बाइक के लिए एडवांस डिस्क ब्रेक बनाए हैं, इट विल फॉल अंडर विच कैटेगरी? Is my screen visible? Patent. Beautiful answer. See, what is happening here? We are talking about technical advancement. Also, there is a term inventor. Whenever you find a term like inventor, invention, advancement, technical terms, technology, it will always fall under patents. Which of the following is geographical indication? इनमें से geographical indication कौन सी है? Geographical indication को हिंदी में भौगोलिक उपदर्शन भी कहते हैं. तो कौन सी ऑप्शन ठीक रहेगी इस क्वेश्चन के लिए, ज्योग्राफिकल इंडिकेशन के लिए? प्लीज आंसर. यू कैन बी फास्ट. आई विल टेक योर डाउट्स आफ्टर द क्विज. प्लीज आंसर. My screen is visible. Correct. You can answer. Geographical indication. The speciality of a region. It is Paithani sari. Paitan is a region in Maharashtra and the sari of that region are famous. Fine. What does a trademark protect? Trademark क्या protect करता है? Please answer.
Sir, screen is freeze.
Screen is finished. Fine. I will try once again. क्वेश्चन ये है, ट्रेडमार्क क्या प्रोटेक्ट करता है?
Sir, it shows slide number 84, sir.
Okay, okay. 84. Okay. एडवांस डिस्क ब्रेक बनाए हैं बाइक के लिए, इसका आंसर दिया था किसी ने पेटेंट्स. फाइन. विच ऑफ द फॉलोइंग इज ज्योग्राफिकल इंडिकेशन? इनमें से ज्योग्राफिकल इंडिकेशन कौन सा है?
Sir, slide is not changing.
Sorry to disturb you in between, sir. Actually, your screen has been freezed towards the side, which is fashion
Okay,
designer's
okay.
room.
Okay, I will try once again.
Yes, sure, sir.
Just a minute. Is my screen visible now? Is it changing?
Yes, sir, it is. Yes, sir, it is visible and it is changing.
Fine. So there was some network issue. We will go to 85 number slide now. Yes, 86. So if there is something called as geographical indication, which can be a geographical indication?
Sari.
Correct. Because Pathan, beautiful answer. Pathan is a region in Maharashtra and the sari of that region are famous. If we talk about BMW, it will be a trademark. Ironing machine with stem, it will fall under patents. PlayStation is again related to technology, it will fall under patent. World Wide Web, it is a set of computer program written, it will fall under copyright. What does a trademark protect? Trademark क्या protect करता है?
Logos, names, and brands.
Logos, name and brand.
Correct. If I go over other option, invention, it will be patents. If there is a work of art, it will be copyright. If it is look, shape and feel of product, the outer appearance, it will be design. Logos, names and brands is the correct answer for a trademark protection. Patent का term कितना होता है? How long do patent usually last for?
60 years.
Any other?
20 years.
20 years. 60 years plus your lifetime is a, you can say, protection you get for copyrights. Say you living for 60 years, say 70 years, and you have some copyright for any content. You will get the protection for 70 plus 60 years, like that. But in terms of when we talk about patent, say you today filed your application for patent 14th March 2022, your protection will be till 14th of March 2042, 20 years only. If you have written some story, it will fall under which category? You have written some story.
Copyrights.
Copyright.
Copyright.
Any work, artistic work. Very good answer. It will fall under copyright. A cricketer is there. Say Yuvraj Singh. We can take an example. Yuvraj Singh has a brand. We can find. YWC is their logo. So these things will fall under which category?
Trademarks.
Trademarks. No, it will not fall under design. See, design is about outer appearance, the pattern, the color. I am talking about intellectual property to show the customers that the cloth are made by. Yes. No. Wait. The first answer was correct by someone. Trademarks.
Trademarks.
It is not copyright. Copyright is about what? Painting work, sketching work, drawing work. Not for the pattern or the design part. Registration for pattern, size, color, configuration, you will file a design registration application. अगर आप पैटर्न की बात करते हैं कि ये कपड़ा कैसा दिख रहा है ऊपर से, तो आप डिजाइन का रजिस्ट्रेशन करवाएंगे. लेकिन आप चाहते हैं कंपनी का लोगो हो इस पे, वो ट्रेडमार्क के अंदर रजिस्टर होगा. अगर आप चाहते हैं इस पे मकबूल फिदा हुसैन की पेंटिंग आ जाए, वो आएगी कॉपीराइट के अंदर. ठीक है. यहाँ पे बात हो रही है, युवराज सिंह अगर ये चाहते हैं कि उनके कस्टमर्स या उनके जो फैंस हैं वो उनकी टी शर्ट खरीदें, तो उनको उनकी कंपनी का नाम पता चल जाए टी शर्ट देख के कि ये किस कंपनी की है. तो बात हो रही है लोगों की, ट्रेडमार्क की, टैगलाइन की. यहाँ पे हो रही है बात ट्रेडमार्क की. अगर हम बात करते पैटर्न की तो आता डिजाइन. अगर हम बात करते किसी आर्टिस्ट के द्वारा फेमस पेंटिंग की तो आता कॉपीराइट. किसी ने नई टेक्नोलॉजी का इजाद किया है. Somebody has developed some new technology to have some improvement over a product. It will fall under which category?
Patent.
Patents.
Patent.
Correct. The training institute, okay, and all officers who join this office, okay, they get trained at RGNI PM Nagpur. If you want any training, intellectual property training, you can just search their Facebook page also, and you can just contact them. 1 week, 2 week program, 1 month program, 2 month program are there for those who want any training in intellectual property right, any type of workshop. Now there is a small animation for you, and after that we will have a quiz for you. Is my screen visible? Can anybody confirm?
Yes, sir, it is visible.
The video has a sound. Just a minute. If the sound is okay?
Sir, video is not visible.
Sir, yeah, the video and audio both is unavailable at our end.
Okay, I am again sharing. Just a minute. This is just a 2-3 minute video, and after this video, we will have a quiz session for all of you so that you can ask your queries. Now, please confirm whether it is okay now. Is it visible now?
Sir, actually now the audio is available, but video isn't available.
Audio is not required. Actually, it is the animation. Just a sound background is there. Background music.
Sir, the
So you
visuals
can
are unavailable.
okay. Visuals are also unavailable. Just a minute.
Yeah.
Again, I will try last time. Otherwise, we will have a quiz session. Screen 2. I think it should be visible now. Is it okay now? Ma'am, is the visual
Yes, sir. Yes, sir.
fine? Fine. So this was the video that the intellectual property is everywhere. When you wake up in the morning till the time you do your activities, you will find intellectual property surrounding you. Now we can have a you can say a question answer session from your side. If you have any questions, just please ask any questions if you have. Any students, faculty member, please ask your question. You can unmute yourself. Fine. If you have any questions, please ask.
Anyone is having any query? Okay, sir. Can you please guide us for the particular one of the case that we have filed for the design patent, sir?
Yes.
Sir, before a year ago, in last March, we filed a design patent, and current status is a case is amended, case of controller, sir. So, what is the meaning of this, sir?
Amended stage. Fine.
Yeah.
Actually, office might have provided you one communication. Fine.
Yeah.
Office quick report provided KOD.
Sir.
And you replied to that.
Yeah.
This is called as amended stage. Now it is under second stage. Okay. So if you get if your clarifications, your arguments are satisfying our requirements, office requirements, okay, then you will get the design registered. Otherwise, what will happen? You will get a hearing. Fine.
Okay.
So second stage means your reply, first reply has come. Now it has come second time to office, like that.
Okay, sir. Thank you, sir.
Yes. Amended
Now,
stage. Amended means you have done the amendments. You are providing the clarifications to our examination report. Yes.
Okay, thank you, sir. Now, anyone is having any query, please ask to
कोई
sir.
भी query आपके दिमाग में आप पूछ सकते हैं. I am comfortable in Hindi and English both fine.
Sir, one more question. Can we file a design patent on the name of institution?
Yes, sir. No issues.
Currently, till last year, it was available for the individual one. Now, can we approach for the institute one?
Sir, I think there is a category.
Okay.
Okay. Natural person or institute. So generally what happens whenever you are filing on behalf of an institute, okay, so your institute becomes the applicant and you become the inventor side. How it is happening in design? How when you file your application, was there any category of applicant and inventor,
Yes,
or
sir.
was there any only applicant category is there? Means what?
Applicant category is there.
आप अपने एप्लीकेंट में इंस्टीट्यूट का नाम रख सकते हैं सर, एंड देयर कैन बी टू एप्लीकेंट्स. आप खुद भी एप्लीकेंट बन सकते हैं, इंस्टीट्यूट को भी रख सकते हैं. जनरली
Okay.
जब इंस्टीट्यूट की तरफ से कोई भी इंटेलेक्चुअल प्रॉपर्टी राइट की एप्लीकेशन फाइल होती है, तो जो लोग ने उस डिजाइन को बनाया है वो भी एप्लीकेंट होते हैं और साथ में इंस्टीट्यूट भी होता है, बिकॉज they were using the institute resources or they were working in an environment in an institute. So it is an agreement between the institute and the applicant or the inventor, okay, that since we have made this invention here, so they made an agreement. जैसे कि जब भी हम कोई पेटेंट की एप्लीकेशन देखते हैं, say we got an application from GIT Gujarat, so how we see it conventionally, कैसे लोग फाइल करते हैं कि जो आपका एप्लीकेंट नेम है उसमें या तो स्टूडेंट्स के साथ इंस्टीट्यूट का नाम होता है या ओनली इंस्टीट्यूट होता है, और इन्वेंटर्स में आपके क्या कहते हैं जो स्टूडेंट्स हैं या फैकल्टी गाइड्स हैं, मेंटर्स हैं, उनके नाम होते हैं. So if you want to put in applicant, you can put institute name as well as the other people who have done this.
Okay. Thank you, sir. Now, anyone is having any query, please ask.
Yes, sir. Sir, if we modified something on the already registered pattern and then uh, either we improve its efficiency or
Correct.
some modification we do and then we can register it as a pattern.
बिल्कुल कर सकते हैं. आप ये सोचिए, आज जो भी टेक्नोलॉजी है, आप जब कुछ भी नया बनाएंगे, यू आर डूइंग समथिंग न्यू, तो आप उसके ऊपर ही जाएंगे. तो कोई ऑलरेडी ग्रांटेड पेटेंट है, but you are doing some technical advancement or you are doing some efficient work in terms of, you say, delay, or you can say cost or efficiency, maybe in terms of some parameters. Okay, so these things you can file patent, fine, because आप existing technology पे आप advancement कर रहे हैं ना, you are doing a modification of existing technology. अगर existing technology पे modification नहीं होगा तो किस चीज पर होगा? Are you getting me?
Okay, okay.
You can file for a patent, yes, because you are doing something more technically advanced than already existing knowledge, and you are making good. Okay, you are making that invention good, or you can say technical advance in terms of efficiency. Efficiency maybe in terms of parameters, or you can say delay, time delay, cost, etc. Like that.
Okay, thank you.
Any other question?
Okay, do we have any participants for any questionnaires? Feel free to ask. I guess it's a no. On behalf of Gandhinagar Institute of Technology, I, Professor Shreya Patel, am very glad and thankful to Mr. Advait Jain sir for taking the time out of his busy schedule and defining each and every content from the very basics. Either it is being what is an intellectual property, either defining how the examination procedure is working, either what was the aim of a patent system, either you give an impactful knowledge regarding what was the first Indian patent and how we can file a patent in India. So we are very much thankful to you, sir, for empowering the knowledge and defining our students from the very basic steps and defining each and every procedure in a very convenient manner. So before bidding a goodbye, I would request everyone to turn on their video camera so we can capture this moment. I request every participant to turn on their video camera, please.
Also, provide me enable chat. Can I put my email ID if someone has any query?
Sure, sir.
Or Jyotinji, you share your email, my email ID later on in your group. Or
Uh, yes, sir. Anything would work at our end. I request every participant to turn on the video camera so we can capture the moment. And feel free to contact Sir in case of any query. Either you can just ping on Sir's email ID. The details would be shared soon. Either it would be reverted via mail, either in the comment section. I'm thankful to every participant for their active participation and support, which was highly appreciated. Without each and every participant, this won't be possible, and it won't be possible for us to organize such events. Sometimes we may lag in responding you, but apologies for the same. Hoping to see the favorable response from everyone's end in the near future. Once again, we are thanking every participant for joining the webinar. Have a great evening ahead. Thank you,
एक
everyone.
बात कहना चाहूंगा मैं कि आप जब पेटेंट के या डिजाइन के बारे में या किसी इंटेलेक्चुअल प्रॉपर्टी के बारे में सोच रहे हैं, आप ये मत सोचिए कि वो कैसे नहीं मिलेगा, आप ये सोचिए वो कैसे मिल सकता है रजिस्ट्रेशन. Generally, people think that what can be the reasons so that I won't get a patent or a design registration. You should always think how can I get a registration. आपको उन पार्ट पे वर्क करना है जो आपको पेटेंट दिला सकते हैं. जनरली पीपल का माइंडसेट बाहर ऐसा है कि कौन सी चीजें नॉट पेटेंटेबल है. अरे आप पेटेंटेबल चीजों पे आप बात करिए, पेटेंटेबल जो चीजें हो सकती हैं आपके इन्वेंशन में उन पे आप फोकस करिए. So you can change, you can just work on some innovative things and you can have intellectual property registration. All the best and thank you for joining the session.
Thank you, sir, for giving the pro tip at the end.
Thank you,
We
Shreya ji.
highly appreciate that too. Thank you, sir.
Thank you, Jyoti ji.